Chairperson.
Good morning, Honorable Ntuli, the Chief Whip.
We have an apology from Honorable Ntuli. Thank you, Chair.
Okay, Honorable Ngola, good morning.
Good morning, Chair.
Thank you so much, Honorable Sokanyile. Honorable Nomvalo. Honorable Skosana.
Good morning, Lochani noke, mqinislalo namalunga wesibethamthetho esiphakamileko. Ngiyanilotshisa noke.
Mandrebele akhethu. Badleli besingefoloko. Honorable Shongwe. Honorable Kola Barnett.
Good morning, Chair.
Honorable Breitenbach.
Well, we've got organizational work today, back-to-back meetings at our headquarters.
Honorable Bangazita. Honorable Sols. Honorable Vessels.
Good morning, Chairperson.
Honorable James.
Good morning, Chair.
Advocate Arense, Advocate Mkize, Advocate Mkhwaizi, good morning.
Good morning, Honorable Chair, honorable members, and everyone else on the platform. Thank you.
Good morning, Chair. Good morning, everyone on the platform.
Mr. Antile Ejana, good morning.
Good morning, Honorable Chairperson. Good morning to the honorable members and to my colleagues. Thanks.
Dr. Thuli, good morning.
Good morning, Chairperson. Good morning to members and colleagues as well. Thank you so much.
Good morning, Bonani. Good morning, Pilot. Good morning, Mr. Mpilo.
Good morning, Chair, and good morning to members and colleagues.
Thank you so much.
Chair.
Thank you,
honorable members.
Thank you so much. African National Congress, do you have apologies?
Good morning, Chairperson. Once again, yes, we have the apology of Honorable Ntuli. He will be unable to join this morning due to organizational commitments. I suspect Honorable Sokanyile is still to join us. Thank you, Chair.
Okay. MKP, record of apologies.
I'm not aware of any. I thought we are all here. Thank you, Chair.
Okay. DA, any apology?
Chairperson Honorable Klopper is on a plane as we speak and will join us as soon as he is able.
Okay.
Chairperson. Chair.
Chairperson. Yeah, we'll come to you. Let's okay. Rotate the parties. EFF.
Chair, Honorable Malema will log in briefly, and then both of us will need to be excused probably in about an hour or so. Thank you, Chair.
Thank you so for organizational commitments.
Yes, organizational commitments. Hosa 2026.
Yeah, no, all of us are ready at that time. Let's meet on the battlefield.
You can't be more ready than us, Chair, but yeah, organizational commitments. Yes, thank you, Chair.
Bangazita, Honorable Mngango. Bonani, do we have any apology for Honorable Mngango? Honorable members will remember that when he left the proceedings last week on Thursday, he said that he has a pressing family commitment that will need him closer to home. And let's keep on praying for Bangazita and his family. Honorable Sol, is there any apology from PA? Bonani, did we record any apology from Honorable Sols?
Chair, none, we have received nothing from him, not yet.
Okay. Honorable
maybe Chair,
okay.
just to indicate that Honorable Klop is on the platform.
Honorable Topper has joined.
Good day, Chair. So I am on. As indicated, I will have to log off within the next 10-20 minutes, and I will log back on at 5 minutes to 1. I do apologize.
You are welcome, Honorable Topper. Honorable Bethel, any apology from your party?
Thank you, Chair. I will just have to step out at a certain stage to take care of an urgent matter, and then at about 3 o'clock, if we're not finished, I have an organizational meeting. Thank you, Chair.
Okay. Honorable James, any apology?
No, Chair. Thanks.
Thank you so much, Honorable Member. The apology on my part is that my flight to Cape Town is leaving at 13 hours. And in the event at that time, the meeting will not be done. I will request Honorable Ngola to preside over the last part of the meeting. Can I request that we flight the agenda for members to look at it and hear if they have input? Okay, honorable members, we must get an update over Mr. Paul O'Sullivan matter. I just want to bring it to your attention that, like the committee decided, we wrote to Mr. Paul O'Sullivan advising him to appear before the committee this week. We should get an update on that during the presentations. And we have also agreed that the legal team will present an opinion on the Mr. Paul O'Sullivan's matter. It has circulated with us. Mr. Tejana will make that presentation. And we should also deal with the scheduling of witnesses. And I'm going to suggest that we take the first 3 items together because they talk to each other, the 3 of them. It will make our meeting easier. And maybe even on the scheduling, in our last meeting, we said the legal team should go and assess the statements of General Msikiri and General Sentumule. So they will, when they talk to the item on scheduling, they will also give us a report on the status of the 2 witnesses. And then we have correspondence from Mr. Honorable Mahlatsi, just to refresh the committee. When we dealt with the submissions that were made by Honorable Skosana and Honorable Sols, Honorable Mahlatsi had made a submission that there was one witness that he felt the committee may have to give him chance to come and present before it. And when the matter appeared before the committee decided that the information which was provided was insufficient. So that was brought to Mr. Honorable Matladi's attention, and he tried to provide more details and motivation as to why that witness must be called by the committee. The committee will interact with that. And then we also have a correspondence from representatives of Ms. Sarah Jane Trent regarding some of what they think are sensitive matters that were presented in our proceedings, and consideration of 7 sets of minutes. I have spoken to Mr. Bonani that we struggled last week with the flighting of the minutes. It took us long unnecessarily, and he assured me that today we will not have the problem that we had last week. It has been attended to. So those are the items, honorable members, on the agenda. Let me check with yourselves if there are any members who will want to add or subtract items from this agenda. I'm on the list of members. I'm not seeing any hand. I'm not seeing any microphone on. My assumption is that the members are agreeing that we must proceed with the agenda as it is. Okay, thank you so much. Honorable Sangoni, your hand is up.
No, it's
And
fine. I was going to help you, Chair, move for the adoption of the agenda, but I think you've passed that. Thank you very much.
Thank you so much. Mr. Tejana and Advocate Arens, can you please take us through the first 3 items?
Good morning again, Chairperson. Good morning to the honorable members and to my colleagues as well. Chairperson, I'm going to deal with the update on Mr. Paul O'Sullivan's matter. And my colleague, Ms. Telana Halistaki, will deliver the opinion on the matter. And of course, Advocate Norman Arens, SC, will take us through the witness schedule. Chairperson, you will recall that on Thursday, the 26th of February 2026, and after Mr. O'Sullivan had walked out of the committee proceedings without your permission and in violation of the rules of the National Assembly and the Powers and Privileges Act, you posed a question to committee members whether it is their wish for Mr. O'Sullivan to come back to the committee and complete his evidence. The committee resolved resoundingly that Mr. O'Sullivan must come back and conclude his evidence, and as he was still under examination when he walked out of the committee proceedings. We can confirm that on Friday, the 27th of February 2026, we addressed correspondence to Mr. O'Sullivan inviting him to appear before this committee on Thursday, 5 March 2026, as he was still under examination when he decided to abandon committee proceedings without the permission of the chairperson. Chairperson, may I also add that Mr. O'Sullivan has been put to terms in that we have informed him to indicate to you his willingness to appear before the committee by no later than today at 12 midday. We can also confirm that in the event that Mr. O'Sullivan does not comply with the committee's invitation for him to appear before it, a summons has already been prepared in order to secure his attendance or his appearance. The summons procedure is provided for in Section 56A of the Constitution of the Republic of South Africa, read with Section 14(2)B of the Powers and Privileges Act. The Powers and Privileges Act requires that a summons must be issued by the Secretary to Parliament on the instructions of the chairperson of the committee concerned, acting in accordance with a resolution of the committee and with the concurrence of the Speaker of the National Assembly. Chairperson, you will recall that on Thursday, the 27th of February 2026, you had taken the committee into confidence by sharing details of a briefing we had with the Speaker of the National Assembly, and which took place on the same day and at the Speaker's instance. All I can say is that the Speaker, as the issuing authority insofar as the summons procedure is concerned, is briefed in this regard. The Speaker indicated that she is at the service of the committee and will act as soon as she is formally briefed about what the committee has resolved in this regard. Chairperson, to this end, I can also confirm that a request for concurrence has been prepared for signature by both the chairperson of the committee and the Speaker, should Mr. O'Sullivan not comply with the committee's invitation. Chairperson, please allow me to rest. I thank you. Over to you, Ms. Halistaki.
Thank you, Mr. Tichana. Morning, Chairperson. Good morning, honourable members. I will take the committee through the legal opinion drafted by the Constitutional and Legal Services Office concerning the incident that took place on Thursday, 26 February, involving Mr. O'Sullivan, while being led by our junior counsel, Advocate Mkhize. Members, as the chairperson pointed out, you have all received the legal opinion. It was circulated to the chairperson on Friday at 8 p.m. I will therefore confine my remarks to a concise executive summary, and with your permission, chairperson, I'm confident that the members have an opportunity to have considered the opinion in full. So this will be really brief. By way of background, members, you will recall that during the examination of Mr. O'Sullivan, he became really agitated and repeatedly indicated that he needed to leave the hearing by 1 to avoid missing a flight. And despite the request from the chairperson and members to remain seated and complete his testimony, he stood up and left the proceedings. The central question, therefore, is twofold, honourable members. What are the remedies available to this committee to compel Mr. O'Sullivan to complete his examination? And secondly, does his conduct constitute an offence or a contempt of Parliament? The legal opinion that members have received analyzes the applicable regulatory framework, including the relevant rules of the National Assembly, the applicable provisions of the Constitution, and 4 pertinent sections of the Powers and Privileges Immunities of Parliament and Provincial Legislatures Act, the PIPPLA. Members are aware that the National Assembly Rule 183 requires any person appearing before the committee, including counsel and attorneys, to observe the directions of and conform to the procedures determined by the chairperson. Further, members are aware that Section 56A of the Constitution empowers the National Assembly or any of its committees to summons any person to appear before to give it evidence. The key issue for legal clarity is what are the provisions in the PIPPLA which are applicable to the present facts. If members will indulge me, I'll briefly address the relevant sections and their applicability. So let's first go through the provisions that aren't applicable in this instance. So members, 17(1)A provides that a person who has been duly summoned in terms of Section 14 must remain in attendance until excused, failing which an offence has been committed. As Mr. Sullivan was not invited and was invited and not formally summoned, this section does therefore not apply. If we move on to Section 13, Section 13, read with 12, deals with the contempt of Parliament by a member who contravenes specified provisions of the Act. As Mr. O'Sullivan is not a member of Parliament, this provision is likewise inapplicable. However, if we proceed to Section 7A of the PIPPLA, 7A of the PIPPLA is of particular relevance. It provides that a person may not improperly interfere with or impede the exercise or performance by Parliament, a House or committee of its authority or functions. And then if we look at section 27, it stipulates that the contravention of section 7 constitutes an offence, attracting liability to a fine or imprisonment. So, honourable members, on a plain and grammatical interpretation of the term impede, it denotes conduct that is obstructs or hinders the progression of Parliament's work. In leaving the proceedings prematurely, Mr. O'Sullivan's actions may reasonably be construed as interfering with or impeding the committee in the execution of its mandate. Honourable members, the committee's terms of reference require it to assess the veracity of allegations advanced by various witnesses, including that of Mr. O'Sullivan, whose evidence was material, particularly in relation to allegations of political interference in police operations. His departure before completing his examination therefore hampered the committee's ability to discharge of its functions in terms of the terms of reference. Additionally, honourable members, if you consider 17(1)(c)(1), 1C1 of the PIPPLA, it provides that a person who fails without sufficient cause to answer fully and satisfactorily any questions lawfully put to them commits an offence. Therefore, members, given that Mr. O'Sullivan left while under examination and without the permission of the chairperson, this provision may also be engaged. In conclusion, based on the analysis set out in the legal opinion before this committee, the Constitutional Legal Service Officers is of the view that Mr. O'Sullivan has potentially committed a statutory offence in terms of section 7A, read with 27 of the PIPPLA. Furthermore, Mr. O'Sullivan has potentially committed a statutory offence in terms of 17(1)(c)(1) of the PIPPLA. The committee is at liberty to invoke its summoning power, as Mr. Techana has explained, enshrined in both the Constitution and the PIPPLA and the National Assembly rules, and is advised to write to Mr. O'Sullivan detailing the recourse as set out above. However, this committee on the 26th of February resolved to invite Mr. O'Sullivan to return to Parliament. That said, the committee is firmly within its rights to invoke any of the above-mentioned legal remedies should Mr. O'Sullivan not comply with the committee's invitation to return to Parliament. Thank you, honourable members.
Okay, Advocate Arendse.
Good morning, Honourable Chair, honourable members and my colleagues, and thank you, Ms. Ali and Mr. Techana for the presentation of the opinion. I have nothing to add. I concur. In relation to Mr. O'Sullivan himself, he has confirmed that he will be in attendance on Thursday. One, to conclude the questioning by Advocate Mkhize. I think she had 2 or 3 questions left. And then, of course, to deal with the matter that's just been addressed. I'm not sure which one, obviously, within your discretion, which one you deal with first. Otherwise, in relation to if someone can just flight the witness or the proposed witness schedule, if I could go through that, Honourable Chair, honourable members.
Advocate Arendse.
Yes, I was requesting someone to flight the proposed witness schedule for this week and next week, because I'm not able to do it from my end.
Okay, I think we must. Okay, no, it's fine.
Yeah.
I wanted to say that, but it's a matter which I think members will raise during discussions. Let's have Mr. Paul O'Sullivan coming, like we advised him to come this week, and the committee will engage with him when he comes, whether it's a full day or it's 5 hours, let him come. I don't think he's coming specifically for Advocate Mkhize because committee members may have issues that they want to raise with him. So let's just say when he comes, it must be for Thursday.
Yes, Honourable Chair, did indicate it's subject to your discretion and the committee members.
Thank you. Thank you so much for your efforts.
But from our side, we had those few questions left. Just in relation to the schedule, tomorrow we have Lieutenant General Moshakiri and General Sentumule. Lieutenant General Moshakiri will appear. A statement has been made available to the honourable committee members for some time now. General Sentumule, however, will not be able to appear and has formally apologized and requested permission not to appear tomorrow due to a medical incident that arose on the weekend. I think it was on Sunday, when my colleague Advocate Mkhize was in the process of conferring with her. The documents have been sent to Mr. Romano by Major General Van Rooyen, the legal person in the National Commissioner's office, and we have no doubt that it's a genuine case. It's an older son of hers who was hospitalized on Sunday. So we would respectfully request that she be excused from attending tomorrow. But we have indicated to Mr. Romano, and hopefully it will be condoned and accepted by the Honourable Committee, that she appears on Friday. On Friday, we had scheduled some public participation witnesses, that the public participation witnesses scheduled on this draft for the 4th of March, that's Wednesday, Mafoho and Chetty, and then perhaps the ones mentioned on Friday, Rapoto and Ramajua, that they be moved to tomorrow afternoon. Obviously, it's not easy to predict what time it will take, but we do not expect Lieutenant General Moshakili to be that long. Certainly from our side, you may recall that her attendance was required because she served as the acting National Commissioner for a brief period when General Masemola was on leave, and the directive from Minister Mchunu was brought to her attention on and after 31 December of 2024. So that's Friday. So we would propose that for tomorrow we have Lieutenant General Moshakili and the public participation witnesses. We have been in touch with Mr. Romano in terms of securing the attendance of these witnesses, whatever travel arrangements have to be made. Then for Wednesday, we propose a swap that Mr. Mashuga testifies first, and if we could perhaps make a 10 o'clock start. Mr. Mashuga might be quite long because he was the prosecutor in the matter against Trent and O'Sullivan. That's the matter that was removed from the roll, and although he's no longer in the NPA, he has indicated that he wishes to testify. His statement is near ready, and in fact, I want to ask to be excused from the meeting. Advocate Mkhize will continue to represent the team so that I can finalize Mr. Mashuka's affidavit during the course of this morning. Mr. Adams will follow with your leave. His affidavit is near ready, and Advocate Mogoetsi is liaising with him. Then on Thursday, we will kick off with Mr. O'Sullivan, to be followed by Sarah Jane Trent, whose affidavit also is near ready, and Advocate Mkhize is dealing with her in that regard. If we could move to the following week. On Tuesday, we have the suspended Inspector General of Intelligence scheduled. He has, according to his counsel that I'm liaising with, he has indicated to the President and to the relevant minister that he's been required by this honorable committee to appear on the 10th. He wishes to appear. So there's still some interaction between him and the President and the relevant minister. And we'll keep you informed, Honorable Chair. And then on the next day, we have Lieutenant General Vuma, whose statement, I think, has been sent already. I think it's finalized. And then we end off on the 12th and the 13th with the National Commissioner, General Masemola, and Lieutenant General Mkunazi on the Thursday and the Friday. Thank you, Chair. While I have the floor, the only thing that I wanted to ask was a request which I have made on a few occasions with Mr. Tetiana, is that given that we are, according to the schedule anyway, only concluding our evidence on the 13th, that's Friday, and given that we still haven't received all the transcripts of all the witnesses, I have asked that that the assistance of our colleague Lerato Sikalala, Advocate Sikalala, who had been on our team up until the end of last year, to assist us with the summarizing the evidence. She was also on our team during a crucial first phase of this hearing, when General Mkunazi, General Masemola, some key witnesses, the suspended minister, Mr. Matlala, and others, all appeared, and it would be most useful to have her assistance. Her assistance would be limited to a number of days that she's able to set aside to assist. But I've been told that it would require, Chair, you and the Honourable Committee to support such a recommendation, which will then go through to the Speaker, who will then authorise the State Attorney to secure her for for that limited period and that limited role. Thank you, Chair. I can take any questions. Otherwise, that's our presentation.
Yeah.
Thank you.
Just to make one point clear, Advocate, tomorrow, because by now we all know that the statement of General Msikidi is very short. Are we able to get, because Bonani has suggested to me that if you were to get some of the public participation witnesses available, they may come tomorrow. Is that what you are also presenting here?
Yes, Honorable Chair.
Okay. Are we succeeding in that regard?
I think Mr. Romano can perhaps speak, Honorable Chair, but we have been liaising with him.
Yeah, so that when members go into discussions, they know that part one tomorrow is going to be General Msikidi, and thereafter we will have one or two witnesses from public participation if they would have confirmed. And so if they have not confirmed, members must know that they may have a short day tomorrow. Mr. Romano, do you have anything?
Yes, Chair. Maybe just to confirm that I had a discussion with Advocate Mkhize this morning. But the discussion was around public participation witnesses scheduled for Wednesday and not including Friday. I am in contact with Mr. Chedi and Mr. Mapo for them to appear before tomorrow. So far, Mr. Mapo seems to be able to appear before the committee tomorrow. Mr. Chedi might have a challenge for tomorrow. With regards to witnesses scheduled for Friday, I can confirm that it will be difficult to get some of them here tomorrow. For instance, one of them is in Lesotho, so it will be a challenge to get from Lesotho today or tomorrow for that appearance. We will try and see if we can get more for tomorrow, but for now, I can confirm that Mr. Mapo will join us. Thank you.
Okay, so now on the schedule, you are presenting the proposal that members must endorse or ratify the appearance of General Msikidi and Mapo tomorrow.
That's correct, but should we be able to secure another witness for tomorrow, we will keep the committee informed.
Okay. Okay. And then for Friday, how many witnesses will be there on Friday? Because all of us by now, we know that Friday afternoons are very, very difficult for the committee. The witnesses that are coming on Friday, are we able to have them and deal with the business of the day before 1, 2, or 3 o'clock on Friday?
Chairperson, with regards to Friday, there are two witnesses who have submitted a statement yesterday. I've looked at the statement and also shared it with the evidence leader and Mr. Tekana to look at and advise. So maybe we'll also share that with the committee so that the members can also have a look at it and advise if it is relevant to the terms of reference. But then should that statement be relevant, Friday we're likely to have two witnesses because the two submitted statements yesterday will be making a joint submission. So
Okay.
yeah, so we'll have Friday, we'll have 2 on Friday, and then we are going to look at the program and see if we can move them forward. But it might be difficult because if you remember, on Thursday we've got Mr. O'Sullivan and Miss Sarah Jane Trent. I don't know how long those 2 will take.
Yeah, it's a matter which the committee members will decide whether they will have a situation where they have both of them on one day, or they want to have them on separate days. Yeah, but I hear what you are saying. So Friday it will be 2, and you have this statement of these 2 witnesses that the committee would have to look at whether they must appear before the committee, or they may be referred to the police portfolio committee. So we will await that advice from the legal team, but their statement can also be made available with them. With the members, not for the purpose of today's meeting, but for members to, at their own time, to go through the statement, and maybe during the week, either tomorrow or Wednesday, we can make a decision. Honorable members, I'm now going to rotate the 3 items. We got the report on the legal opinion, what is being suggested. Number 2, the latest on Mr. Paul O'Sullivan, that it is proposed that he must come here on Thursday. And there is also the proposal that Ms. Sarah Jane Trent must also be here on that day. Members will advise, we will hear from you whether you want to have both witnesses on one day, or you would want to separate them, so that we don't have a situation where one of the witnesses feel that they have not been given sufficient time. If you remember, when we met with Mr. Paul O'Sullivan for the first time, he was not satisfied with the time allocation, because he said he wanted to say, he had a lot that he wanted to say, and he felt that there were so many things that were said about or against him, and he wanted to clarify them. So if members feel that they have issues that they may want to raise with Mr. Paul O'Sullivan, we must know now from this meeting that when he comes on Sunday, it's the whole field day, or whether he comes for half a day. And if he comes for half a day, we can field or allocate Ms. Sarah Jane Trent for the afternoon. And then if it means we must have one, we will then look for other dates where the other candidate will come. And the last item would be the schedule that has been presented here with the proposed amendments that Mr. Ramano and Advocate Arendse have just added, to say we will have General Musigidi and maybe 1 or 2 witnesses tomorrow. There has been a request from General Sintumule that she has a situation in her family, and she will need to be there to give support to the child. So that is the request that she is making before the committee, for the committee to allocate another date. Those are the 3 matters, the 3 items that were circulating before the committee for discussion. the African National Congress.
Yeah, thank you. Thank you very much, Chair. Let us welcome the reports as presented. And I would have thought that the matter of Mr. Teenage Kumbbe, I think it is, you would have probably put here as part of scheduling issues. But let me speak to the matters that the Chair is directing us to speak to. On the matter of Paul O'Sullivan, Chairperson, the African National Congress welcomes the decisiveness with which this matter has been handled by both yourself, Chair, as well as the Speaker. We fully support the approach that Mr. O'Sullivan was invited, and had he failed to avail himself, he would be summoned. But we do want to once again make a point that him now conceding, or at least agreeing to appear on Thursday, does not negate, nor does it take away the fact that an offense was committed on that day. We've gone through the legal opinion and we concur with most of the legal opinion, except for what we think is a very narrow reading of, I think it's section 17, if I'm not mistaken, of PIPPLA, where I think in the interpretation, the legal advice given to us seems to suggest that because he was not summoned, he was only invited, therefore that section doesn't apply. We think that if you were to take a purposive interpretation of legislation, it doesn't necessarily seek to distinguish between summoned and invited witnesses. So we do think a broader reading of that legislation would indeed apply to Mr. O'Sullivan as well. It's a point that we're raising just for noting, Chair, because we do think that even read then with the other sections, the case is still made that an offense was committed. Now, him appearing on Thursday does not mean that that offense falls away, and we would support that we still look at what action that can be taken with regards to that, because you do not want to open up a precedence, a can of worms, where anybody thinks that as and when they feel like it, they can just walk out of Parliament, then they will be invited back. I don't think that that's the message that we're trying to send to society. So we really support the pursuing of further action in relation to that offense that has been committed. Chairperson, on the second matter that you raised was, before we step off on the Paul O'Sullivan matter, it would be very good also, Chairperson, if we were given clarity. Because I know that this continuously comes up on defense by the defense. When Mr. O'Sullivan seeks to defend himself, that he says there was an agreement for him to leave at 1300 hours. I do not have a recollection of the chairperson telling us before that Mr. O'Sullivan will be released at that particular time. And I think it's important just for us to clarify ourselves to understand whether indeed there had been such an agreement, because I suppose it does raise whether then he was justified or not in his behavior. In the absence of that agreement, well, even if there was an agreement, we still think that an offense was committed, because even if there had been an agreement, he cannot dismiss himself when he's under oath. And I think both the Constitution and the law is clear on that matter. The second issue, Chair, on the scheduling of witnesses, I think the administrative changes that are being made, we don't have a problem with. We also accept the apology from General Sentimule with an understanding that the legal team working together with the committee staff will look at rescheduling her appearance again. And also the issue of Advocate Zikalala being brought back. I think we support that. Chair, I am just I'm just worried about the timing, and I'm hoping that bringing back Advocate Zikalala is going to assist us on this matter, because the extension that we have is until the 31st, if I'm not mistaken, of March, which means that by then we should have concluded our business, which includes the adoption of the report. Maybe we just need an assurance that the 2 weeks that we are giving, tight as it is sufficient time for the legal team, Advocate Arens's team working together with our committee team to finalize that report and ensure that it's put to us for deliberation before that date of 31st of March. Let me stop there, Chair. unless you give me permission to voice an opinion on the issue of the proposed witness, Mr. Teenage Kumbbe. I don't know if we're still coming to that. Thank you very much.
Yeah, we are still coming to that one, Honorable Sangweni. I think it's the next item. Can I check Tejana or Advocate Arendse? Do you want to respond to the question that Honorable Sangweni posed here regarding the arrangements with Mr. Paul O'Sullivan last week?
I've raised my hand, Chair. Don't forget about me. Thank you, Chair.
No, we're still coming there. I think there is just one matter that must be clarified, that when you come to speak, it enriches your understanding of issues.
Chair, can I speak? Or is there?
Yes, Advocate Arendse, you are allowed.
Honorable Chair, honorable members, we never make any agreements or enter into any agreements with anybody, any witnesses, because we don't have the authority to do so. What we do is to say we will convey whatever it is to the committee chair. We normally do that through Vonani. And in this case, it was made, there was no agreement that Mr. O'Sullivan should leave early or at a particular time. What I did convey to you also, Honorable Chair, was that he needs to leave because he's got a 2 o'clock flight. And that was the extent. And I think on several occasions, Mr. O'Sullivan, from where he was sitting, may have indicated that he needs to leave. But there was no other agreement. As far as I'm concerned personally, and as evidence leader for this committee, it could have been much better conveyed, and certainly to simply get up and leave without having completed his evidence, and certainly without any permission from the Honourable Chair and the Honourable members of the committee, it was unacceptable. So that, in terms of the background, is yes, he did indicate to us, which I had shared with Mr. Romano and the Honourable Chair, that he had to leave to catch a flight at 2 o'clock. Yeah, but I can't speak for him otherwise, Honourable Chair. Thank you.
Thank you so much. Honourable Skosana, do you want to ask a question, or you want to be given a chance to speak?
Chair. Chair, it's Leanne Matthys. Oh, thank you, Chair. I've had my hand up for a while. I was just hoping that you would allow EFF to go next on these 3 matters. We're just about to start our next meeting, and we'd like to make a submission to the committee.
Yeah. Okay.
Can we go in?
Let me allow you to, and thanks very much for reminding me. Let me allow you to speak, and then the other members will be given a chance.
Okay, thank you, Chair. We really appreciate you just going off the process that we normally follow. We obviously have gone through the legal opinion, and we appreciate the time that the legal team put into it. In line with what Honorable Sangweni said, there's two different processes here. The fact that he's decided to come and appear again voluntarily does not cancel out that he was in contempt of Parliament. So the processes that are available to us, which includes opening a case of contempt, must be done. As you know, that a case has been opened, so we would like to make a recommendation that the committee recommends to the Speaker or whoever needs to do it, that they submit an affidavit to the case. We've already received the case number supporting that the matter, or supporting rather the investigation of the case, and then obviously ultimate prosecution, etc. So we are in line with that. In terms of the witness schedule, we're also fine with it. Just one of the things we do want to raise is that we don't have the same problem, one, with the scheduling of witnesses, and then the evidence leaders have not received the information in time. They haven't gone through it, and then we are shocked that some of the statements were not properly processed, and then information on there was not incorrect. So we hope that it wasn't just a matter of the statements being sent and we checked that they were signed, and then it's come before us without the evidence leaders properly going through it, and also our Parliament legal team, if that was the process that we are going to follow. Also, in terms of Paul O'Sullivan, there was also that matter that we received both a legal opinion about, and we submitted our letter to the Speaker of when he threatened one of our witnesses, Kabinde. And there's been no action on that. So maybe this is the time for us to discuss with the Speaker and the Speaker's office on what we need to do with that matter, along with this contempt of Parliament charge that we should be laying. Thank you, Chair. That's our input.
No, thank you so much, Honorable Mathes. Let me come back to you, Honorable Sangoni, because I'm not sure if you have concluded.
Yes, Chair, I've concluded, and I think the response to my question assists in that regardless of whether there'd been an agreement, the witness was still under oath. So our position has not changed. Thank you, Chair.
Do you still have any other speaker under your leadership who wants to contribute?
They are silent, Chair, so I think they are covered. Thank you very much.
Okay, you speak in one voice.
Thanks, Chair.
MKP.
Thank you very much, Chairperson. Let us first welcome the report that we've been given by our technical team. We think we would have done a very good job. The report is well balanced, and we commend them for preparing concurrently the invitation of Mr. Paul O'Sullivan with the drafting of summons. We want to commend them for that. But with regards to the Paul O'Sullivan matter, even if Chair, he had indicated to our technical team that he will leave at 13 hours. That is immaterial. When we're in a committee meeting, you subject yourself to the directives of the chairperson and to the directives of the committee. So if you don't adhere to the directives of the chair, you are contempting Parliament. So whether he made that indication or not, we don't think that that would be material under the circumstances. So we are supporting a call, Chair, that says, yeah, we must embark on a twofold approach. The first one is that which has been done by the legal team of inviting him to come back to the committee. And the second one is to attend to an offense that he has committed, an offense of impeding Parliament in its duties. So we must not overly focus on one aspect and overlook the other aspect. I think that is very important. And secondly, Paul O'Sullivan is not going to prescribe questions and time. And I think you have covered us very well there, Chair, to say when he comes back, we're not necessarily going to deal with the outstanding questions by the evidence leader, Advocate Kumbbe. There are new matters which are arising now and are arising from his conduct. And we want to take those matters further. Hence our submission that members must be afforded, once again, an opportunity to engage with him, because there are many matters which are outstanding that we must discuss with him, and which specifically arise from his conduct that he displayed on that day. Chair, and then because we're dealing with we think this is a perceived proposed list of outstanding witnesses. There is a witness that once appeared before our committee, and he was turned away while, before he made his testimony in Parliament. I think the reason was that because he is a former employee of SSA, so there are some prerequisites that he must comply with. So there is no accountability of that witness. What happened? Did that witness approach the SSA? And why is he not part of this list? Is it because SSA did not approve his appearance? And if that is the case, that would be worrisome, because SSA is an executive body. So the executive body can't tell Parliament how to run its activities. It can't tell us how to run our investigations, because our investigation might even go to a point where we investigate them. So if executive institutions have a determination of how witnesses or which witnesses must appear before us. So we just need an explanation, Chair, in that regard. There is that witness, I think you still remember him.
Honorable member, we received your apology and it was recorded in the last meeting. That matter was reported comprehensively. We can brief you about it, how it was handled.
Okay, no, it's fine, Chair. Honorable Skosana will come in and take it from where I've left off.
You can proceed, Honorable member. You can proceed.
Chair? No, I'm saying Honorable Skosana will proceed, Chair. Am I audible?
No, yeah, but before, because Honorable Matthijs has also raised a matter on the report on the matter of Mr. Kabinde.
Yeah.
You still remember that incident? I want to hear you.
Yes.
You haven't spoken to it.
Yeah, that is why, Chair, I'm saying Honorable Skosana, because we are speaking in one voice, will proceed.
Oh, okay, thank you so much. Honorable Skosana.
Thank you, Chair. I think, Chair, it's very important that we stand firm on this matter of Paul O'Sullivan. I think the Speaker as well, or Parliament, must open a case against Paul O'Sullivan. One, the issue which we are now reminding Honorable Nomvalo about the threat which O'Sullivan did when Kabinde was a witness as well. I think it must come as well now on the table. We can't leave this thing unattended. And I think as well, Chair, the fact that there's this issue that he will come, that does not cancel the contempt of Parliament. The process must continue.
Sure.
The process must continue. Now, threatening a witness is a serious issue, Chair. It cannot be just left there and say, no, you know what, whatever happened, happened. No. The witness, Mr. Kabinde, told us to say why he was still testifying. He received that WhatsApp message. And we all know what does that mean. We can't leave Paul also Sullivan with these issues and say, you know what, is going to dictate terms to us. We must make sure that the Speaker or the Secretary of Parliament open a case against Paul O'Sullivan. This is a contempt of Parliament, and the issue that he has threatened the witness, that cannot be left in the dark. And I guess as well, South African Police Service, because in that precinct of Parliament, the integrity must be maintained at all costs. Once we are in that precinct, it's parliamentary precinct. Whether we are outside Parliament, in the parking, we are in Parliament, it has to be respected, Chair. So I'm saying in closing, Chair, is that Parliament must open a case against Paul O'Sullivan for the contempt of Parliament. And the issue of Kabinde must as well. That threatening WhatsApp message while you are still a witness, before us. Indeed, we must make sure, because we never even received the report or on the legal opinion of that threat up to date, because we were promised that we're going to get a report on that issue of Kabinde, that threatening WhatsApp message to Kabinde. What did the Parliament did with that? We don't know as members of this ad hoc committee. And I think, Chair, that must be attended as a matter of urgency. I thank you, Chair.
Honorable Breitenbach.
Thanks, Chair. Yeah, we accept the recommendations of the legal opinion. Mr. Sullivan is coming back. Let us cover the issues with him that we wish to cover and finalize the matter. And however we choose to deal with the surrounding issues is a matter for the committee to perhaps discuss at a different stage. For the rest, we agree with the submissions, Chair. Thank you very much.
Thank you so much, Honorable Breitenbach. I assume that the DA speaks in one voice.
Always.
The PA, Honorable Sols.
Chairperson, before I make my contribution, may I also say that I was delayed a bit this morning because I'm not in town and I am traveling back soon. So if I excuse myself during the meeting, I ask your indulgence, please, Chair. And my contribution in terms of Mr. Paul O'Sullivan, we do believe that he's in contempt and he must be dealt with in accordance with PIPPLA. And then as far as the administrative changes are concerned, we are covered, Chair. Thank you so much.
Thank you so much, Honorable Sols. Honorable Vessels.
Thank you, Chairperson. I agree on all three issues. Nothing to add. Thank you.
Thank you so much, Honorable James.
Thank you so much, Chair. We support all the submissions made this morning. Just on, I think, the legal opinion. I want to ask, when Mr. O'Sullivan reappears on Thursday, who's going to be liable for all the costs that's been incurred? Will it be him or will that come to Parliament again? And then also, we are happy with the schedule of witnesses. That's all. Thank you, Chair.
you still there, Chair?
Oh, I have not unmuted myself. I'm sorry.
Okay.
Honorable James, I was saying that the last matter which you have raised with regard to who will foot the bill, it's a matter which the logistics team of Parliament will have to deal with. I should think that within their means or their arrangements, they know the economically effective ways to deal with the business of Parliament. And if they have any issues, they can always raise them with Mr. Paul O'Sullivan. I think they know our sentiment. And the other matter which members have raised with regard to opening of cases, we will elevate those matters to the office of the Speaker and report to her what the decision of the committee or the strongest sentiment of the committee is, that the committee feels that cases must be opened. And the office of the Speaker will make a decision on whether it seeks a legal opinion on the matter or it just goes straight out and opens a case. We will get a report from them how they would have dealt with that matter. But from our part, we will report to the office that the committee strongly feels and has decided that what Mr. Paul O'Sullivan would have done is a contempt of Parliament and would have violated some of the provisions in law, and steps would have to be taken against that behavior. And I think the rest of the issues, the members have spoken unanimously. We are going to move to the next two items on the agenda. Bonani, if you can bring the agenda again, we see which items are being presented. Okay, let's take those two items on correspondences. Is it you, Bonani, presenting, or is it Mr. Tejana?
Chair, maybe the first one, I think that would be the committee, or maybe the evidence leaders might also come in. If you remember, there was that request for Mr. Kumbbe to be invited to appear before the committee. Mr. Kumbbe sent us a document, I think last week, which I have circulated with members of the committee, including the evidence leaders. So all that we need is guidance from the committee on whether Mr. Kumbbe should be invited to appear before the committee. The next one, I guess Mr. Tejana will address. Thank you, Chair.
Who do you suggest is presenting the two items?
Chairperson, Mr. Ramano has presented the first one. It's just the second one that has not been presented. Remember, Chair, the statement was sent to members for members to go through it and guide us in terms of whether they want Mr. Kumbbe to appear in person, or perhaps whether we can take his statement as having read into the committee record. Chairperson, you will recall that when Ms. Van Zyl presented the committee report last week, our view was that not every witness has to come in person before the committee. Of course, the committee will lead us insofar as that is concerned. For us, any statement which has been submitted before this committee will have to be factored into when the time for the compilation of the report comes. So I think, Chair, the issue is members must guide us, having read Mr. Kumbbe's statement. Do they want him here in person, or is it just enough to consider his statement as having read into the committee record? Thanks very much.
Can we take the next item on correspondence?
The next item, Chair, and I think we had asked that the letter itself be circulated to the members of the committee as well. Chairperson, here we have a letter from the legal representatives of Ms. Sarah Jane Trent. And I think at the heart of it, Chairperson, is an issue that arose even last week when General Patlane was being led. And I will refer to it, Chairperson, as the impugned text downloads. I think the point that I'm making, Chair, here is that if you look at the manner in which the phone itself of Ms. Sarah Jane Trent was stolen, that renders the texts themselves inadmissible. And of course, the proper process to follow that, in other words, if you were to test the evidence of those text downloads, you would need a trial within a trial. And of course, as you know, Chairperson, and I think Advocate Mashuha will speak about this, that matter was struck off the roll 9 years ago. So what they are saying, Chairperson, is that their client will come, she has committed to do so, before the committee to give evidence, but she doesn't expect to be asked questions about evidence which is inadmissible. And you will see, Chair, that in paragraph 7, there are certain demands that they place to the committee. That number one, they have handed back, okay, let me just read paragraph 7, Chair. So as a result of the egregious breach of Ms. Trent's constitutional rights during February 2017, that is when her phone was stolen. And again, before the ad hoc committee, were instructed to demand that by noon on Monday, which is today, 2026, that you provide us with a written undertaking duly signed by each and every committee member, stating that they have handed back to you as chairperson of the ad hoc committee the purported download of Ms. Trent's stolen phone, and that the same have been placed in safe custody, pending an order that they are declared unlawful and may be destroyed. 2, they no longer have a copy thereof in their possession, whether corporeal or incorporeal, that is hard or digital copy, and that they shall not pose any questions pertaining to anything that they may have seen on the said purported download of Ms. Trent's stolen phone when Ms. Trent attends the ad hoc committee to give evidence. So that's the summary, Chair, of what the letter says. Our view, Chairperson, is that if you look at the committee's terms of reference, particularly at paragraph 4.1.11, it also speaks to the infiltration of the criminal justice, and I think IPIT would fall after that. And in our view, the alleged romantic relationship between Ms. Trent and Mr. McBride is important in order to verify or ascertain the veracity thereof. It is important that the committee must put the question about this alleged romantic relationship between her and Mr. McBride. However, Chairperson, we are of the view that the committee should not make use of the impugned text downloads when questioning Ms. Trent about the alleged romantic relationship between her and Mr. McBride. So Chairperson was saying the question itself is not illegitimate in our view, because if you want to talk about the infiltration of the criminal justice system, and I think the allegations relating to Mr. O'Sullivan and by extension to Ms. Trent, particularly when insofar as IPIT, is concerned, dictate that that question should be put to her. But Chairperson, we would caution the committee that the committee in doing so should not make use of the text downloads, Chairperson, for the reason you've listed, that it seems as if the legitimacy, the admissibility of these text downloads, Chairperson, is under question. I rest that, Chairperson. Thanks very much.
Okay, thank you so much. But I am not hearing what are the proposals. What are the proposals before the committee on the two items that have been presented?
Now, Chairperson, as Mr. Ramano said, the committee must merely tell us whether they want us to call Mr. Kumbbe to come and present in person, or they will just accept his statement, which was provided to the committee members as a part of the record of the committee proceedings.
So on the first item, the proposal is that Mr. Kumbbe can be allowed to make a written submission, or the committee, if it feels there is something substantive, it can invite him to come and appear. Is that what is being proposed?
That's correct, Chairperson.
Okay. And then on the second one, what is being proposed?
On the second one, Chairperson, I propose that the committee directs us as the legal team to write a letter to the legal representatives of Ms. Trent, informing them that for these proceedings, the question of whether there was a romantic relationship between their client, which is Ms. Trent, and Mr. McBride is pertinent. In other words, it's relevant, because part of what this committee is looking at is the issue of the infiltration of the criminal justice system. And of course, IPIT is part of that. However, Chairperson, what we're saying, even though we don't question the legitimacy of that question, in other words, even though we say that question has to be put to her, we're saying that the committee should not place reliance on the impugned text downloads when doing so. Thank you very much.
Thank you so much. I think the committee members have heard the proposals. I'm now circulating. I'm starting with the African National Congress.
Thank you very much, Chair. I think on the first matter of Mr. Teenage Kumbbe, as the ANC, we do not have a problem with Mr. Kumbbe appearing, provided that he is firstly able to be accommodated within the set time frame that we have. So it's not an additional day that has to be created, but it is within. We welcome that UAT would have brought this matter to the attention of the committee, but also having said that, in the interest of consistency, like we did with the other witnesses, we should be furnished with reasons why this did not come to us during the public participation process. So that request for condonation, like other witnesses were expected to do. There's also an issue, Chair, in his letter or statement, I'm not sure, which I think we should take very seriously, because Mr. Kumbbe says he's willing to appear before the committee, but sets out certain conditions, one of which relates to the provision of protection for himself and his family. Now, to the best of my understanding, it's not within Parliament's remit to do that. And I think that Mr. Ramano and the team would need to go back and engage with him to say that in the event that Parliament is not able to do so, advise him how whistleblowers are protected in the country, and perhaps it may be then a matter that has to be considered under that regime. In which case, then I think that the matter would then fall within the Police Portfolio Committee. However, if he's willing to appear nonetheless, can provide reasons that are acceptable to this committee, and we are able to accommodate him within our existing schedule, then we have no problem, Chair. The second issue of Ms. Sarah Jane Trent and her lawyer's letter, I think we should make it very clear that we are not going to be intimidated by that letter, which is expecting all committee members to, within the next 32 minutes, sign a letter and undertaking about what we've done with the evidence that was before us and so forth. I think we must be very clear. In fact, it's a bit contemptuous in its approach. I would think that having read the letter, it makes out its own case. It talks about a trial within a trial. It means that there are points in limine that need to be discussed before Sarah Jane Trent appears, and that is whether the information was obtained lawfully or not. Now, the only evidence that the committee has before it is the one that was given by General Pahlane under oath in a sworn statement relating to this matter, where General Pahlane avers that the information was obtained legally. I think it would be relatively easy for us to contact SAPS to seek a corroboration of what General Pahlane said, whether indeed this is when the phone was downloaded, and that is where then the information comes from. Perhaps, I don't know, SAPS seems to have been quite responsive, because if we could get that response, say, earliest by tomorrow morning, then we will proceed with Ms. Sarah Jane Trent. Chair, you may also, I think, perhaps also in engagement with Honorable James, I see that she's mentioned in the letter as well, without bringing it to the meeting, just to ascertain that indeed the information at her disposal was obtained lawfully, which, however, becomes a moot point, because if we're able to corroborate the evidence that General Pahlane raised that it was obtained legally, then I don't think there's a problem with any other member, including Honorable James, to have access to that information. So I think, yeah, Chair, our submission insofar as the Sarah Jane matter is concerned is let's corroborate the evidence that we got before us from General Pahlane, that the phone was downloaded in compliance with the law. And if that is the case, then we proceed. And I think if it was then obtained unlawfully, it is a bridge that we'll have to cross when we get there. But be that as it may, Chair, Ms. Sarah Jane Trent should appear on Thursday. We will have to, I think, once we have the information at our disposal, decide how we navigate, the issues of the questions. It's things that we know now anyway, I don't think we can pretend to unknow them. They are there, and as Mr. Dekiana was saying, they are a key part of the questions that we need to ask in relation to infiltration of the SAPS system. And I'm not talking about romantic relationships. I'm not interested in that. But her role that she would have played together with Mr. O'Sullivan, particularly in the General Pahlane matter and others. Thank you, Chair. I'm not sure if Honorable Ngola or Honorable Sokangile want to add. Thank you very much, Chair.
Yeah, we call it corroboration.
Yes, corroboration. That one.
Yeah.
Thank you.
Yeah, those are some of the tongue twisting words. Can we move to Honorable Skosana or Honorable Nombalo?
Yeah, no, thank you, Chair. Am I audible? I've been trying to unmute here.
Yes, we can hear you, Honorable Member.
Yeah, no, with regards to the first matter, Chair, we agree with the latter speaker that let's engage Mr. I can't pronounce his surname properly, but let's engage with him and tell him how we can meet him halfway in Parliament and do what is doable and what has been done to other witnesses. In as much as we value evidence from various witnesses, but we can't go beyond necessary. So I don't understand now when there's a request for security for his family. But the technical team must engage him. And in the event, Chair, he doesn't agree with what Parliament can offer to him, I think an alternative of him making a written submission can be explored. Chair, can I proceed?
Yes, you can
Hello?
proceed.
Hello?
Proceed, Honorable
Chair.
Nombalo.
Yes, Chair, I can hear you.
Yes,
Can you hear
proceed. Me? Yes, we hear you.
Oh, yeah. So I was saying, Chair, yeah, so an alternative of him making a written submission must be explored in the event he doesn't agree with what we can offer to him as Parliament. Then on the Sarah matter, Chair, I think this letter is very insultive. We are being insulted by Kabinde here, and we must not take that lightly. No one is going to prescribe to us on how we must ask questions. This letter is prescriptive. They are telling us to ask this and not to ask that. We're going to ask questions which we think are relevant in the context of the terms of reference. And Chair, the legal team must have authority from us. They must reply to them, to those attorneys or lawyers, and tell them that we're going to ask questions which are relevant to the terms of reference. And anything that they are telling us, we're not going to regard it. And if that would make them not to appear, their client not to appear, so be it. Then that would mean we're going to have another a problem that we will have to deal with. It means we're going to have a person that we will have to summon for her to come and appear before us. So we must not agree, Chair, to these conditions. These are prescriptive conditions which are going to undermine the very same authority that we have as this committee. So we don't agree with this one in its entirety. It seeks to undermine and it seeks to continue with what Paul O'Sullivan has done to us. So we're not accepting this, Chair. The legal team must write and they must inform those legal representatives of Sarah that there is no question which is relevant that we are not going to ask. Whether that question is related to a romantic relationship or not, if we think it is necessary to be asked from the witness, we are going to ask that question. Thank you very much.
Thank you, Chair.
Proceed, Honorable Skosan.
Yeah, indeed, Chair. I must say that we cannot be dictated here. You know, whether those what do you call it, WhatsApp messages have been taken away or been redacted from us, that doesn't matter. We are going to ask questions which we think are relevant. No attorney, no firm of attorney will dictate to us how to question the witness, Chair. It never happened anyway. You know, if that's the case, then they must go to court and tell the court that they don't want their client to be questioned. This is Parliament, Chair, and we've got term of reference, and we know what we are talking about here. I'm not going to get into others because my colleague has already said about the other issues. But no witness can dictate to us like what Paul O'Sullivan wanted us to do. We cannot allow that, Chair. That cannot be allowed. In fact, let's not even entertain it at all. It's like they wrote a love letter once again. Thank you, Chair.
DA.
Thanks, Chair. Yeah, I don't know quite what to say. Chair, we may well be Parliament, and we may have terms of reference. It doesn't mean that we operate outside the bounds of the law. It doesn't mean that we have unlimited rights. I haven't had sufficient time to apply my mind to this letter, really, and to the contents. And I agree that witnesses shouldn't be able to dictate what they get questions on or not. But there is a question of legality here that we do need to consider, but I would need more time to apply my mind to that particular issue. So, yeah, I will go with the legal advice. Thanks, Chair.
Honorable Sols.
Yeah, this is a bit of a tricky one, I think. Obviously, I'm just a normal MP, and this is just an opinion which the legal team can provide more accurate guidance on. To me, it seems like a clash now between what protects us, which is the Privilege, Powers and Immunities Act, against the Criminal Procedure Act that Ms. Trent's attorney is using. And we then need to decide on that dilemma. My first issue is number one, does this letter then imply that the WhatsApp messages that was read into the record is the letter indirectly saying that Ms. Trent is saying that it is indeed messages from her phone? That's number one. Number two, was the phone actually stolen or illegally obtained? This happened 9 years ago. The case was struck off the roll. There is no actual legal surety. There's no actual verdict in a court of law that says that the phone was stolen and or it was illegally obtained. And to steal something is a criminal offense. So it's a crime. So it has to be, the onus is on the person who alleges a crime has been committed to prove this beyond reasonable doubt. And as the committee sits here, we don't know beyond reasonable doubt whether this phone has been stolen, as it is said, or illegally obtained. And the attorney has to make that clear to us so that we then know, based on a court of law, the information that's read on the record is a fruit from a poisonous tree, as the attorney says. So I think from outside as the committee, in our oversight role, the second part of the messages has been given as part of the testimony of General Paslane, and he stated under oath that he's not lying to the committee. So that information was not received by the committee through illegal means. We, in good faith, believe that the general has obtained that information legally. of course, outstanding now. We will hear from Honorable James whether she can also confirm that she has obtained the information she produced through legal means. I feel once both that is satisfied that Honorable James got it through legal means, we assume that based on the fact that General Paslane has said so under oath that he also received it or acquired it legally, then that satisfies that what is on the record before the committee has been acquired legally. And so if need be that we have to question on issues around that WhatsApps that relates to the terms, our terms of reference, we should be able to do so. And again, I'm asking, based on the scenario I've painted, I'm asking for legal guidance because, of course, I'm not at all a technical expert on the matter. I'm just it's just an opinion and my reading of it. So the legal team can confirm. But I also feel, Chairperson, that we should not be dictated to as to we must respond by 12. If not, then this and this and that. That is not a good approach or posture for any witness to have, even in the attempt to protect your constitutional rights. But for me, is it a protection of constitutional rights? Fine. But is that also an indirect admission that what was read into the record is actually WhatsApps from Ms. Trent's phone? So we need clarity on that. I think that's my take, Chair. So maybe with guidance, I would say that it seems like we can continue under PIPPLA when clarity, legal clarity is brought on those issues that I've just raised. Thank you, Chair.
Honorable Wessels.
Thank you, Chairperson. On the first issue, I agree with the Honourable Sangoni that there's engagement with the witness and that we proceed in that regard, and in the alternative that we accept a written submission. With regards to the attorney's letter and the WhatsApp messages, I think it's a very complicated issue, and it can be made very complicated because at the end of the day, if she says that she was illegally arrested, then those messages were obtained illegally. But as the Honourable Souls also said, it has not been adjudicated upon that it wasn't an unlawful arrest as far as I know. But this will end up in litigation, Chairperson, if we insist that we're going to use the messages. I think we're going to delay proceedings because they will litigate. I think we should accept the legal advice that we deal with it in that manner, to write to the legal representative and say that we are going to ask questions of relevance with regards to the relationship, because that is relevant to our terms of reference, and leave it there. I also agree that we should not be dictated to, but I don't think we should insist that we are going to use the messages at this stage. Although it's true that it has not been adjudicated upon, we're just going to delay the process. They are going to go to court most probably, and then we're not going to get the witness in before us in time. So for the sake of proceeding and getting the witness and having the chance to scrutinize the relevant matters, which is the relationship and the infiltration of IPID. Let's agree, or let's follow through with and do as the legal advice is. Thank you, Chair.
Chairperson.
Honorable James.
Chairperson.
Who is that?
It's Honorable Souls. I didn't comment on
let's do
teenage.
this, Honorable Souls. Honorable Souls.
Yes, sir.
Let's allow Honorable James to speak. If there is any matter you want to clarify, we will come to you.
No, I didn't comment on the issue of the teenage question,
Yes,
teenage
yes.
Kumbbe question, yeah. But if you
Yes.
want me to wait, I'll wait, yeah.
If you can, I request you to wait.
Okay.
And allow Honorable James. We will give you a chance to comment.
Okay, Chair.
Is that okay with you?
No problem. I just wanted to say I think he must appear in person. That's all.
Okay.
Okay.
Honorable James.
Thank you, Chair. Chair, on the first matter, that Mr. Kumbbe, we can engage and then proceed from the matter from that point. And then secondly, on the letter that we've received from Sarah Jane Trent's lawyers, this is not the first time this committee is being threatened by lawyers. And we said it when, I think it was Mr. Katmatlala's people that also threatened us and said, you must get back to us by this time or else. Let them take us to court and let them do what they need to do. Imagine being threatened and dictated to by someone who herself obtain information on various people illegally, on a person that has infiltrated our state and asking for information and sending ministers' ID numbers around. And she now has the nerve via her lawyers to tell us that we obtained this information illegally. We cannot be dictated to as a committee. We said that we are protected by the parliamentary privilege in how we obtain our information. We also said that this committee hasn't been blessed with a forensic investigator, and therefore we've had to do our own digging to basically get to the truth and to the bottom of all this. We cannot be threatened with legal action because of the way we ask questions or obtain our information. She also cannot come here and make us sign an undertaking in 30 minutes that she mustn't be asked questions. Let them do what they want to do. Let them take us to court if they want to take us to court. But she herself obtained information illegally. And that is our stance. We're not going to be dictated to, and we're not going to be told here what to ask and what we cannot ask. Thank you, Chair.
Honorable Souls, I'm back with you.
No, Chair, I just wanted to say that I think Mr. Kumbbe should appear in person. And I take it that on the issue of the how the information was acquired from Honorable James, I take it that it was acquired legally. So, and we take that in good faith. So my suggestion stands that in that case, the committee didn't get it through illegal means. Thank you, Chair.
Thank you so much, honorable members. We are going to accept decide the way members have proposed here. Number one is that on the matter of Sarah Jane Trent, I think the legal team is right, and members have said that we will write back to her and respond in the manner which is being proposed. And number two, that even when we do that understanding that the citizens of South Africa have rights, and that as a committee, our powers are not limitless, but also importantly that the rights of the citizens are also subjected to the law of general application, where you can't just have a citizen saying, because I have rights, this and that cannot be done. I think let's not talk confrontation. Let's talk about how best we can bring the witness before us, and the witness responds to questions to the best of his or her ability. But the committee cannot not also be impeded from doing its work because it is being threatened by this and that. I think in whatever manner we respond, Ms. Sarah Jane Trent must understand that within our terms of reference, we are investigating interference by members of the public and doing the kind of the work that she was doing. If there is any way in which her alleged relationship with the officers of the SAPS or IPIT have in one way or another impacted on their conduct or influence certain actions or decisions that they would have taken, she can't come before us and say, you can't ask me questions about the following things. There are certain questions which we will not ask, but we can't ask them how many times they met or how many times they did what. But we can ask whether indeed it's true that her relationship could have influenced certain decisions. And if there is nothing to hide, I think she can always respond to the committee and say, look, this was just a social relationship. There is not in any way, we kept it professional. We did not influence any decision. Whatever decision would have been taken, it would have been a decision of people who have studied every case and arrived at certain conclusions, not because of whatever social relations or affairs that could have been. I think we just have to indicate to her, and members are right, that witnesses can prescribe to us whether on what they should be asked and what they cannot be asked. And then on the other matter, Mr. Honorable Mathatsi has requested that the committee must listen to Mr. Teenage Kumbbe. Mr. Teenage Kumbbe appeared on a television platform. I think it could have been one of the three main TV stations in the country, news stations. And then he made the statement that he made about his knowledge of corrupt activities happening. And that is why Honorable Mathatsi wrote to us. And we wanted to know from members whether we could take a written statement from Mr. Kumbbe or he could appear before the committee. And what I hear the committee members saying is that, number one, they must explain in the same way as we laid those conditions, explain why they have not met the deadline. And number two, I think with regard to the conditions that are being made to say, in the event I come, I will want Parliament to take care of my security and this and that. Those are the things that the team of Parliament could go and look at. But we must also be wary of Parliament being abused. I don't understand why a witness says, I want to appear before Parliament. And then or somebody recommends that witness so and so must appear before Parliament. And when that witness has to come before Parliament, all of a sudden there are conditions that I can appear, but I only appear on the following conditions. I don't think that this is what we are looking for. So we will first have to wait to get an explanation as to why the witness has not complied with the 31 October deadline. And from there, we can then decide that we are going to take a statement or to schedule the witness to appear. With that having been said, honorable members, I think we can move to the next item, which is the minutes. Bonani, you write the first set of minutes and then you will title them by the date.
Chairperson.
Chairperson. Chairperson.
Yes, Bonani.
No, it's Andy. I just wanted to request you to release me because there are urgent matters which I have to attend to.
Okay, no, you are released.
Thanks, Chairperson.
Yeah, the minutes are up.
What is the date of the minutes?
The 4th of November.
Yeah, I think what you do, you say these are the minutes of the 4th of November. And then you go to page 1, 2, 3 until the last page. And when you are done, we move for corrections and then adoption.
Noted, Chair. I'm on page 1. Page 2. Page 3. And that's the end.
Okay, any correction on the minutes?
I move for adoption, Chair.
Honorable Breitenbach moves for adoption. Any seconder?
I second the move, Chair Kusela.
Thank you so much, Honorable Sangoni. Bonani, can we get to the next step?
Chair, the next one is 5 November. Page 1. Page 2. Page 3, which is the last page.
Any correction? Any mover?
I move.
Thank you, Honorable Breitenbach. Any second?
Seconded, Chair.
Thank you so much. Can we move to the next set?
The next one is 6 November, page 1. Page 2. Page 3. And page 4.
I move.
Chair, we have a correction. Chairperson.
Correction, Honorable
Yes,
Sangoni.
Chair. Honorable Nola was present in the meeting. He can't appear both as present and apologies. If we could just take him off apologies. He was in the meeting. Thank you, Chair.
Thank you. Honorable Breitenbach has moved. Any seconder?
Seconded, Chair.
Thank you so much. The next set.
The next set is 11th of November, Chair. Page 1. Two. 3. Page 4. 5. 6. And 7 is the last page.
Okay, any corrections? Any mover?
Chair, I move.
Any seconder?
My second, Chair.
Thank you so much. The second last set.
The last one, this is the last one, 30 November. Page 1. Two. Page 3. 4. 5. 6. 7. Last page. Page number 8.
I move, Chair.
There is a mover. Any seconder?
Seconded, Chair.
Thank you. Let's take another set, Bonani.
Chair, we had only distributed 5 to members. That was the last one.
Oh, okay, that was the last item of the meeting. What time are we starting tomorrow, Bonani?
Chair, members had indicated that they wanted to start at 10. I don't know if there are changes to that.
Oh, the members are here.
Subscriber you have dialed is not available at 7.
10 is great, Chair.
Subscriber you have
The members are here. Can we hear if they agree to 10?
10 is excellent, Chair. Thank you.
Thank you so much. Honorable members, 10 o'clock tomorrow, we have come to the end of the meeting. Thank you so much.
Chair. Thank you.
We will
Thank you very much.
meet tomorrow at 10.